Welcome once again to Lehto's Law. Here's Steve Lehto.
I step away from the camera for 30 seconds and the world explodes. My messages are blowing up and going, Steve, check this out. Steve, check this out. So everybody seems to have sent this story to me. I talk about AI from time to time and about how it's crept into some places it shouldn't have. And a lot of attorneys have gotten in trouble for using AI, including the attorney who filed a brief in defense of his use of AI and used AI in the brief and then got caught doing that. And a lot of attorneys who claimed that they didn't know that AI would hallucinate cases. It's gotten to the point now where it's pretty much a joke when somebody gets caught using AI in legal pleadings in a court. Because everybody is on notice that the AI does this kind of stuff, the hallucinations and made-up cases and so on. So the reason everybody sent me this story is who should know this by now? Well, all the attorneys should know it, right? Okay. Their staffs should know it. Legal secretaries, paralegals, whatever, clerks. They should know that AI is something you got to be careful with. Who else? Who else should know this? Who else should know this? Well, we've heard a lot of judges ripping on attorneys for misusing AI. Maybe the judges should know. No. Steve, are you about to tell us that some judges don't know this? Certainly you can't be suggesting like a federal judge. Oh, let's try plural federal judges. And of course, you know this because so many people sent me the story that you know where this is going. So this is from Bloomberg Law, but widely reported. Justin Henry wrote the story. Judges, plural, admit to using AI after made-up rulings have been called out. I predicted this, but so did a lot of other people, and it didn't take a genius to see it coming. If attorneys are handing in briefs with made-up cases in them, and they're not pointing it out to the court, if a court relies on that brief, there's a chance that the court's opinion is going to contain a made-up case. And we've heard of judges where somebody said, hey, judge, your opinion contains this case. We can't find that case anywhere. Where'd you get it from? I got it from a brief. Turns out, you ask the attorney, where'd you get it from? ChatGPT told me it was a good case. ChatGPT has said a lot of things. So it was inevitable. And I hoped that by hammering on this more, as many people like me are doing, that judges would all be on notice that you got to be really careful nowadays. So 2 federal judges blamed their own faulty rulings on the use of AI tools being used by their staff members. This is not stuff that was done by attorneys turning stuff in. This was judges asking their staff members to do research and write stuff for them. And it raises questions about how much they scrutinize documents that are issued under their names. And I've mentioned before the idea of signing a pleading. When an attorney signs a document, submits it to the court, the attorney is vouching for it. When a judge signs an opinion, it's even more important that it be accurate because orders of the court are what courts do. Courts speak through their orders. So if you're ever in court and you see a judge bang his gavel and make a pronouncement, what makes it official is when it gets reduced to writing, order of the court, with a date and a signature line and a stamp and a bunch of other official seals. And if they are inserting made-up cases in those orders and opinions, that is a serious problem. A U.S. district judge in New Jersey and another one in Mississippi admitted to these foibles in letters to the administrative office of the U.S. courts. The 2 letters were sent October 20th, 21st, in response to questions by the Senate Judiciary Committee, and they were reviewed by Bloomberg Law. The mistakes raise concerns about the judiciary that can't be excused by the advent of generative AI, says Bruce Green, a professor at Fordham University School of Law. The judge's excuses raise the question of whether judges are regularly publishing draft opinions, meaning an opinion that somebody drafted that they didn't go over to the point where they can say, yes, I stand behind every word of this. The mistaken rulings and the judge's responses to them show that courts can expect the same kind of scrutiny for oversight of AI that judges themselves have brought on lawyers practicing before them. Several lawyers have been sanctioned for their improper use of AI in crafting filings, and as I pointed out, one even went so far as, while defending himself, doing it again. So one judge said in his letter that an intern in his office used ChatGPT to perform legal research, resulting in a June 30th order that contained case quotations that didn't exist. The intern didn't have access to confidential or non-public information when using the AI tool, he said. Now, there's a problem. An intern who's from law school implies he's not even a lawyer. He's doing research using ChatGPT. Why? Seriously? Are they not teaching the students in law school that you can't use ChatGPT like this? Is the judge or his staff not telling the interns, don't use ChatGPT? And you can make it stop real fast, because all you got to do is say use ChatGPT one time and you're fired. And if anybody ever calls for a reference, we'll tell them why you were fired. So do you want to use ChatGPT after being told that or no? The second judge said his law clerk used the AI tool Perplexity as a drafting assistant, resulting in a temporary restraining order that referred to parties, allegations, and quotes unconnected to the case. The judge said the clerk didn't input any confidential or non-public information about the case into the program. But again, they're worried about the wrong thing. They're saying, look, we didn't give any proprietary or private information to this program. That's not the problem. The problem is that you were relying on a program that was giving you gibberish and you were assigning your name to it and making it an order of the court, including a temporary restraining order, which I've filed motions for TROs. I've gotten them before. They're a ton of work, and they're usually extremely important, and they're time sensitive. That's why they're temporary. And the idea that someone goes to all the work and applies for a TRO, and it gets granted, and it contains nonsense. It's very troubling. It's troubling. The judge wrote, it was a draft that should never have been docketed. This was a mistake. He added that there was a failure to put the draft opinion through the final review process. So as the Senate is looking at, if this only got caught because of the use of ChatGPT or otherwise, how many other opinions out there or orders have gotten through, drafted by a clerk, but not vetted by the judge? The judge's name goes on it. The judge is the one who's supposed to be checking it out. Neither judge responded to requests for comment on Thursday. Hey, why don't the judges just ask ChatGPT to respond for them? Why not? Let's go full circle here, people. Whether drafted with AI or traditional research, judges are accountable for making sure the citations in their decisions are real. Now, they attribute that idea to Stephen Gillers, a professor at New York University School of Law. I suspect that you could call 1,000 law professors or former law professors and say, do you agree with this statement? Whether drafted with AI or traditional research, judges are accountable for making sure that citations and their decisions are real. If you ask 1,000 law professors, you'll get 1,001 yeses. I agree with that statement. The judge has to read the case which they cite, says the professor. If the judge is citing a case, whether it comes from AI or a clerk, the judge should read that case. Obviously. So the director of Fordham's Law and Ethics Center said the judge's mistakes raise questions as to how often they're docketing unverified drafts. Was it just an incredible coincidence that on the rare occasion that two judges inadvertently released draft opinions, that the draft misused generative AI? Mathematically, it sounds improbable, right? So one judge said in his letter that moving forward, all drafts of decisions in his chambers must undergo an independent review by a second law clerk before being submitted to him. Hey, how about you just read it? He also said that all cases cited in an order must be accompanied by printouts of those cases. Hey, that's not a bad idea. The second judge said his intern's use of ChatGPT defied his chamber's policy against the use of generative AI in legal research and for drafting of orders. He said he now has committed this policy to writing, whereas before it had been a verbal understanding. He said, I've taken preventative steps in my chambers. And so, like I said, what you tell your clerks and interns is you don't use ChatGPT or any generative AI when you're doing research or work for me or this court. And that is a hard and fast rule, a single violation of which will cause you to get discharged, will let you go. I don't know if the interns are being paid. I don't know. Interns sometimes are, sometimes are not. Clerks, they have different terms for this. But you tell them, if you do that, we'll treat that as the most severe mistake you can make in this office, right up with some others. Okay? So understand that's how serious it is. And before you say, Steve, that sounds awfully harsh, I'm just asking them to do the work the way it's been done for the last, 250 years in America. Almost 250. We're getting there, right? How did they do it before ChatGPT? It wouldn't be that hard to figure out, because ask anybody who's slightly older than you, and they'll tell you. Giller says that banning AI is an overreaction, considering how common it has become in the practice of law. I disagree with that, because I'm saying it should be banned, the use of it in the court by the court staff. If you want to use it as an attorney or as a professor and you want to live dangerously, knock yourself out. But ask yourself what happens the first time that it gets caught where something made it past your sensors. What the judge should say is learn how to use it carefully, he said. The judge who bars use of AI under any circumstance is misguided. And again, I disagree with him. However, we can agree to disagree. I don't think he's wrong. I'm just saying what I would do if I was the judge. But the reason I would say it is I'm concerned that a law clerk who's done this and missed the fact that it made up facts in the TRO or made up cases in the order, in the opinion, if the clerk missed that, they shouldn't be using it. Oh, I won't make that mistake a second time. So the senator began an investigation after both judges rescinded and replaced the rulings that lawyers in the cases had flagged as problematic. He doesn't have a specific recommendation beyond asking courts to ensure the rights of litigating parties aren't being trampled by new technology. He put out a statement that says the judicial branch needs to develop more decisive, meaningful, and permanent AI policies and guidelines. We can't allow laziness, apathy, or over-reliance on artificial assistance to upend the judiciary's commitment to integrity and factual accuracy. So there's a little bit more, but I'm going to stop right there because here's the thing. Let's not look at being in a court as a job, okay? There are a lot of jobs out there where you can cut corners, right? So I've had a few of those jobs in my life, and it didn't really matter if I did the job 100%, I could get away with 99. I could get away with 98, right? And I became a lawyer. And as a lawyer, I can't cut corners and do those kinds of things. But it's even worse for a court, because instead of thinking of this as a job that a clerk has or an intern or a judge, think of this from the viewpoint of a litigant. You are a person who has a legal issue. You've hired an attorney. A lawsuit's been filed. Your attorney has rushed to court to get a temporary restraining order to protect some vital interest of yours. And you assume that your attorney's doing their job right, and they run to court with this, and you assume the judge will do their job right. The judge grants a TRO, and you read it, and it's got stuff in there that's gibberish. What's this all about? Your attorney's got to go back into court. Now, by the way, you're paying your attorney by the hour. Your attorney's now got to go back into court, probably bring a motion, and ask the court to clarify the TRO because it contains gibberish. Now, the judge who has a job to do, it's not a bad job either. I don't want to be a judge, but if I was going to be a judge, federal judge is the way to go. The judge has a job to do. And it looks like the judge leaned a little bit too heavily on his interns or clerks, said, here, you take a look at this for me, take a crack at it, let me know what you think. And they drafted something, the judge looked at it, said, oh, this looks good, and filed it. Submitted it to the court, made it official, the court clerk. Okay, you're the litigant now who has to pay your attorney to go back into court and ask the court to clarify where the gibberish in that TRO came from. Meanwhile, you've got important interests that caused you to want to file a lawsuit to get TRO in the first place. Think of it like that. Now suddenly this isn't just a little mistake somebody made. This is something that just delayed your TRO from probably being instituted as soon as it should be, because you got to get that clarification on those weird facts that shouldn't be in there. That's a very serious problem. And any clerk or intern or any secretary or anybody working in a federal court for a judge, a federal judge, should understand how serious that role of that judge is, how serious the role of the court is, and what role you play in that extremely important situation. And the fact that somebody's using ChatGPT or equivalent to draft a temporary restraining order that's filled with nonsense and submits it to the judge, and the judge says, yep, looks good to me, and enters it. Well, the judge signed it. The judge made a serious mistake here, but so did the people underneath them. There's mistakes all over the place in this thing. And I'm getting tired of talking about ChatGPT. The judges know. The attorneys know. The clerks should know. I've heard people talk about they're discussing these kinds of things in law school. I hope they're discussing how much trouble you'll get in if you screw it up and how easy it is for ChatGPT to screw it up for you. I'm just one guy. I'm just a guy talking to a camera with a very nice microphone. But I taught law school for 10 years. University of Detroit Mercy School of Law in Detroit. Okay? I'm here to tell you that I'm not in the classroom right now. But if I was, I would be screaming about ChatGPT every single day. And when I gave the students a written assignment that they had to turn back into me, I would go over it with a fine-tooth comb. And if I found a hallucination in something they turned into me, I would, not in front of the class, but I'd pull them aside and say, excuse me, what's that? This case doesn't exist. Where'd that come from? Oh, ChatGPT did that. Oh, did ChatGPT sneak in and grab your homework and do this behind your back? No, you asked ChatGPT to do this for you. That's the output you got from what you put in. You put in the prompt, you got this garbage back, and you submitted it to me, and you signed it, figuratively speaking. And then I'd explain, you do understand the role that you play as a lawyer. When someone hires you and tells you to look out for their interests, and you do this and submit that to a court, and then a judge will be yelling at you, not as nicely as I'm talking to you right now. A judge will be yelling at you, possibly in front of your client and in front of your opposition, and possibly with a gallery of spectators. Do you want that to happen? So maybe this will be a learning experience. Let this be the last time that ChatGPT embarrasses you. But if it happens again, I can't save you because I did my best to warn you. Somehow, a little over 34 years ago, I scraped through law school without ChatGPT. I didn't have a laptop. The only guy in my class with a laptop was a guy named Rod who sat in front of me who was rich. His laptop cost more than my car. Okay, it was a while ago. Somehow, I got through. Okay, and I passed the bar. I've been practicing that for 34 years. I still haven't used ChatGPT for anything. I'm going to be the last holdout. I'm going to be the last guy on earth who never used it. Okay? That's my goal in life. And the reason is I'm inspired by these things. So here we go. Again, everybody who sent this, thank you very much. Bloomberg Law published it. Justin Henry wrote it. Judges admit to using AI after they're caught with made-up rulings. One in an opinion from the court, one in a temporary restraining order, both of which had to be straightened out and blamed on the people who work in the courtroom, in the back office there with the judge. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. The reason I talk to myself is because I'm the only one whose answers I accept.